What kind of impact can this LBRY ruling have on the industry? Jonathan, what's your take?
Yeah, so just to be clear, they won on summary judgment, but the court hasn't ruled on any kind of injunctive or what the damages will be or disgorgement or anything like that. So that's still to be decided on that. Another thing to clear up just before we get into it is the fact that there wasn't an issue on whether future sales would also be considered sales of unregistered securities, or if secondary market sales are considered sales of unregistered securities. Unlike the Ripple case that's currently pending, this one was an exceedingly narrow issue. They were really going after just one of the four prongs of Howey. First Circuit treats it as three prongs, but it's the four prongs of Howey, and the only thing they were really at issue was expectation of profits based solely on the efforts of others. So it was that and fair notice. Those are the only two at issue. So as far as how this is going to affect other things, it is important to point out that first, we don't know what the ruling is as far as damages and things like that. And second, that this was a narrow ruling on fact-specific issues. That said, it is a bad ruling. It is a bad thing for crypto tokens. Lots of people looked at LBRY as doing things the right way. They weren't doing the ICO. When they released, they had a fully developed platform. The tokens were consumptive. There was an actual use for them on release date. They did traditional investment raise. They bought on shareholders and did a securities and then venture investing. And they didn't sell tokens as a part of that. There wasn't any kind of pre-token allowance as a part of that. And then they waited a year until after the platform was already working and functional, and there was a good amount of videos on there. I know the SEC disputed how much was there and how much it costed and how much the consumptive purpose really was because of how little it cost to actually publish on there. But the point stands that they did things in a way that lots of people in the industry looked at and said, this is as safe as you can do at the time. Obviously, practices have changed. That's not how people release tokens anymore. It's not really the common practice. But at the time, they did things in a way that lots of attorneys would look at them and say, if you're going to release a token, this is about as good as you can do it. So that's the issue here, is that these tokens and these specific sales were deemed securities in a way that lots of people were looking at, all right, maybe under Foreman, maybe courts will say, yeah, if there's utility, then we're not going to treat it as security. If it is true consumptive use, we're not going to treat it as security. And the court said, no, we don't really care about consumptive use. It doesn't really matter as far as the Howey test comes in the First Circuit. Remember, this is just one circuit, one judge ruling on a very narrow issue.